Hi everyone! For today's video, we are going to discuss the case of Landicho vs. Sia, GR number 169472, January 20, 2009. Ponente, Puno CJ. Facts. The instant case involves 3 parcels of agricultural land located in Barangay Mationa, Tayabas, Quezon, which were owned by the Aragons. Said agricultural land was tenanted by late Arcadio Landicho. Upon the latter's death, his son Francisco Landicho succeeded him in his tenancy. Francisco Landicho cultivated the landholding with the help of his son Beneventura Landicho and his brother Federico Landicho. Subsequently, he surrendered his tenancy rights over the landholding in favor of Eloisa Zulota, married to Alberto Aragon through a notarized kasulatan sa pagsasauli ng gawaing palayan. Despite the execution of the kasulatan, the petitioners continued in the possession and cultivation of the landholding. Years after, another kasulatan evidencing the surrender of rights was executed. On the day of the execution of the second kasulatan, the Aragons sold the landholdings to Felix Sia, who managed to convert the use of the land for residential purpose without their clearance. Thus, the Landichos filed a complaint for disturbance compensation. The Dar Provincial Legal Officer ruled that Francisco Landicho cannot be awarded disturbance compensation because he voluntarily surrendered his tenancy rights over the said properties twice, and for Bonaventura and Federico Landicho, it was found that they are merely farm helpers and are not entitled to disturbance compensation. The Dar Legal Division affirmed the same. The petitioners then filed a complaint against the defendant before the Darab for fixing and payment of disturbance compensation and awarding of home lot. The Darab rendered the decision in favor of the petitioners. So then, respondent Sia appealed the decision to the Darab, which affirmed in part the decision of the provincial adjudicator, and deleted the award of disturbance compensation on the basis of the finding that the petitioners are still bona fide tenants in their respective landholdings. Sia then filed a petition for review with the CA, which set aside the decision of the Darab. Petitioners then filed a petition for reconsideration of the Court of Appeal's decision, but it was denied. Hence, this petition for review on certiorari of the decision of the CA. The issues in this case are: first, whether or not the petitioners are bona fide tenants of the land purchased by the respondent, and second, whether or not the cause of action of the petitioners already prescribed at the time of the filing of the complaint. On the first issue, the court said no, only Francisco Landicho was the bona fide tenant, but said tenancy relationship was already extinguished since he surrendered his tenancy rights, and that Federico and Beneventura were just farm helpers as part of his immediate farm household because the essential elements of consent and sharing of agricultural produce are not present. For the second issue, the court held yes. An action to enforce rights as an agricultural tenant is barred by prescription if not filed within 3 years, under Section 38 of Republic Act No. 3844. It took them about 5 years to file a protest before the Dar Legal Division of Lucena and 7 years to file a complaint before the Darab. Clearly, their cause of action has already prescribed. A decision and resolution of the Court of Appeals under review are hereby affirmed. So that's the end of our discussion. Thank you.